And even if the LDA doesn't contract directly with the attorney, they're still doing, what was I going to say? They still work very closely with attorneys, right? So a client comes in and they refer all the time. They have access. Yeah, and yes.
So Elizabeth, whatever comment you wanted to make, you should probably go ahead and do now since you're already speaking.
I was just going to say, maybe this isn't the time, but maybe it is just in that case, can we carve out where we put a line that says, unless that LDA can show that, let's leave this waiver, if the LDA can show that they have been working with an attorney in the last 4 years and there's an attorney who's willing to sign off on that, and an attorney who's been in practice for at least 5 years, kind of similar to like the clause for paralegals.
Okay.
Just
so let's wait on, I mean, because that sounds like a proposed amendment to a motion that we don't yet have. Carolyn?
Oh, sorry, can I please follow up? Because I was asking a basic question, and I just wanted to say Elizabeth was sort of going to where my question was directed, which is there some carve out somehow? So that's all I wanted to say. Thank you.
Okay.
I guess the only thing I wanted to say as the chairperson of this subcommittee is that I really think that if we start doing all these different carve outs, we are going to be making life miserable for the state bar, who already is going to have to review transcripts, administer tests that will let people waive out of a requirement academically. And I guess having trained paralegals supervise them in practice and now formally teach them, knowing LDAs and what they do, I just think this is such a higher, when an attorney is supervising an LDA or a paralegal, you're doing it to a different end. And I think the end that we are seeking here is a much more sophisticated legal professional than we have otherwise had non-attorneys be. And I think that we should not lower the requirements for counting this, that, or the other thing and making the state bar make those determinations. I think it's really important to have a framework to work with, or I just think it's going to be too many moving parts. And I just am not agreeable to that. I think we worked really hard to make the framework what we did, and we think that the experiential part is very important. And I think Steve Hamilton has convinced me of that.
Okay. All right, Judge Yu, did you want to follow up?
I'm so grateful that Steve and you, Julie, have so much experience. And listening to Steve, I realized it was like his own personal experience, which makes it even richer and more helpful. I guess where I'm coming from is my perception is Elizabeth is sort of out there on her own, because most of us judges and attorneys, and I wanted to just explore her position. Plus we had someone in the public comment who sort of stated what Elizabeth stated. And I know it will be possibly more work for the state bar, maybe not, because they're already going to be entering into that foray and doing the work. But I'm also mindful of trying to not make a second class of or third class of people that maybe if they are working with attorneys, they are being supervised to a higher end that you have mentioned, that perhaps it's just more inclusive and more fair and maybe even more racially inclusive, because it could be that there's minorities who are doing LDA work where maybe there are more people who are white who are becoming lawyers. I just wanted to spend some time to look at that, because I didn't feel it was right for Elizabeth to be the only voice on this.
So speaking of that, Judge Yu, as far as Elizabeth being the only voice, we do have in the attendee column, Angela Grijalva, who has her hand up and has relevant experience. I'm going to ask
Can
Linda.
I say one thing, Justice Petro?
Okay.
I just want to speak to the fact that Angela Grijalva is a student of mine. Angela is a paralegal. So by virtue of having the paralegal certificate, they are not in the position necessarily have been doing this work. Paralegals are not advocates.
Okay, so, but I would like to hear from her. She has her
Okay.
hand up and, you know, we're trying to have an inclusive conversation. So
Absolutely.
Angela, just a couple of minutes, please.
Thank you, Professor Brynelson. So, yes, just really quickly, and I appreciate, yes, I do qualify. However, I'm the president of the local chapter here in Sacramento County, the capital city chapter of CALDA. And many of our members are these Section 1A candidates with only the high school diploma. However, a lot of them have 20 plus years of experience. And I want to give you one example. And provide that insight. One of our chapter members recently helped a very savvy self-representing litigant who was fight against and win against Wells Fargo in the repossession of their home. And that's exactly what the ATLS task force was established for, to address, and that's what the paraprofessional program is looking to do. So these LDAs, the Section 1A1 or LDAs, let's call them for short, with the 20 plus, 10 plus, she's had 10 plus years of experience. These are the people you want. So that's where I think that caveat, that carve out, the way Elizabeth is suggesting, and Justice Petro is suggesting, I think that's exactly where we want to do. We need to add the minimum 4 hours, 5 hours, or excuse me, 4 years, 5 years, whatever you want. But these are the people you are looking to bring on board. And just to speak more about how, yes, we work regularly hand in hand with attorneys. I work on a regular basis with greenhorn attorneys. They hire me as a consultant when they're going into a new practice area because they don't know what to do. When they have one-off jobs or one-off cases, like I can't tell PA attorneys, they get like, oh, I got a divorce that's happening. Can you help me? Absolutely. I have law firms that are my clients and I prepare the pleadings in the attorney's names constantly. Of course I don't appear because it's the firm and they're my client, but absolutely we work. A lot of us attorneys and law firms are our regular clients, not just per se litigants. So,
all right, thank you. So
yeah.
Angela, if you could wrap it up, please.
Okay. What else do you want to know?
Anything else you want to tell us? And otherwise I'm going to turn back to our panelists because we have people who are waiting to speak.
Can I ask Angela one thing, because I think Elizabeth came to our subcommittee. There, as far as I understood, based on what Elizabeth said to the subcommittee, there is not a large number of A1 LDAs compared to the LDA's population.
Well, to be fair, that survey that was done within our association, we didn't have a lot of turnout. Here's what we have to look at it in terms of the layers and generations, right? Because that was a 1999 grandfather clause. That was an older generation that had been providing the services to the public, similar to the 6450 grandfather clause. Yes, but that one was 2003. But anywho, and so yes, nowadays, I do mentorship all the time for free to help people. There's a whole new generation of LDAs with the paralegal education, right? But and that's where you may see there's a larger, how do you say, representation in this time. But those seasoned people that you are looking for that should be part of this program are in that older generation. Are many LDAs right now, they're in their 60s, 70s. I mean, they have been practicing that long, and man, they are good.
That's fine,
So,
Angela, but this is a different career than being an LDA. So
okay, so we're not gonna, let's not have conversation back and forth. Angela, thank you for jumping in. And let me go back to the panelists, please. And Fariba.
I just wanted to reiterate that it's a different role, not only a legal advocate, but also they can give legal advice now. Yeah. There's an art to that. There's a skill. They have to issue spot. They may come in for child support, but there may be another issue that they spot and they have to talk about that. So there's a lot of strategizing. And if they don't do it just right, it is really going to harm their client's interest. So that's where this experiential hours will
Understood.
come very handy. Thank you.
Okay, Carolyn?
Okay, keeping it brief. I really appreciated both Olivia and Julia's comments because I learned something from both of them. And I learned from Julia that about the ethical requirements playing into this in a way. I hadn't thought about that before. And I am very, very, I really feel Olivia's comments very much. If we did not have the in-court requirement, I think this could, that what she said in ways in these different things would be very important, especially if you could tailor it to helping low income, kinds of operations, on a, eviction defense network style. So I think what she, I'd really like to hear more about Olivia's thoughts and comments. But in that vein, I'm with Steve Hamilton on this. The in-court thing is just killing it for me. The other thing is I wish we could also see the regulation, the pilot, and the licensing all together in one day and really vote on those up and down at the same time. I think it's just impossible to kind of combine all these without seeing how they're going to impact each
I think we're done with pilot, unless I'm missing something.
No, and I just wanted to clarify, Carolyn, I think you're referring to Elizabeth Olvera.
Right.
Olivia.
Oh.
Okay.
My
All right.
apologies. I'm tired. It's a long
Yeah,
day.
understandably. It's Friday afternoon at 2:30. Stephen, did you wish to be heard or not? I thought I saw your hand, but now I don't see it.
30 seconds. I just want to reiterate, when we were developing the experiential hours, we were trying to come up with a model that was something less onerous than what Washington had and rigorous enough to ensure the paraprofessionals could carry out tasks without knowing that we were going to improve in-court representation. Any reduction of the experiential hours or giving prior credit to me is problematic because paralegals, legal document assistants are not having in-court experience. When I was doing my law office study program, I was also licensed to do the in-court appearances. I argued my first appellate argument before I became an attorney, but I had the in-court experience and I had the attorney there supervising me. I really do not want us to modify in any way, shape, or form the experiential hours in light of our decision to allow in-court representation. Thank you.
All right, so on that note, I was about to see if there was a motion, but I think Elizabeth just raised her hand.
I just wanted to quickly say, it'd be interesting to see the timeline, right? Like we heard from Leah that this might come out in, January 2023, and then you have people going to these courses, and then they have to do the attorney supervision. When is the actual paraprofessional going to be able to open up their shingle? So that'd be interesting to see, like when that's expected, and that's why I'm saying eliminating that one part of because like one part of the and getting that waiver would put more pool of qualified people on the ground. And the reason for it is because I don't know that someone's gonna be able to do that education course and attorney supervision and try to still handle, their family life or whatever. So I just wanted to mention that maybe a visual representation would be helpful. Thank you.
I think our chair has her hand up.
Yes, because I'd like to speak to that. If the rollout is January 23rd, Stephen and I have designed this that it could be accomplished in 1 year. If you don't do it full time, then it's going to take longer. But we wanted to make sure that this was the case. So, it's even like with the legal document assistants, they can become a paralegal in 1 year and then they can do this course. These are doable. So if it was full-time, a full-timer could arguably get this done in a year. I don't know when they'll be ready to start with the certification exams. Nevertheless, that's going to be on the state bar.
Sure. Judge Ian? Oh, can't hear you.
You had asked for a motion, Justice Petru, so I was going to move the resolution with my request that I'm wondering if there's any sort of group think about, or maybe group will, to modify and to add a carve out. But if there isn't, then I would move the resolution to move
Well,
forward.
I think you need to, let's move the resolution, see if there's a second, and then see if there's an amendment, a proposed amendment for a carve out, whether that is, you know, the high school diploma folks or the experiential waiver. But so I've heard you to move this as it is currently written, as is typed up on the screen in front of all of us. Is there a second?
Stephen Hamilton, second.
Okay. And any further discussion? Request for amendment?
I'd like to do a friendly amendment if, to do that carve out of allowing LDAs who have been working under the supervision of an attorney and have an attorney to sign off on that, for that they've been working for at least 5 years. If you guys can accept that friendly amendment, that'd be great.
I will accept that amendment.
I do not. So I think it's going to have to
Right.
this one's going to have to pass or fail. And if it passes, that eliminates the amendment. If it fails, then there'd be a new motion that would include the carve out.
I withdraw the motion then.
Okay.
And I'll make a new motion with the carve out.
Okay, then I think we need to actually know what that language would be.
And I saw that it was starting to be inputted.
Sorry, I'm going to try to bring it back.
Thank you.
Control Z is your friend.
I know, I'm trying.
Certainly my friend.
Absolutely mine.
Yeah, but the thing is, since I undid it, it's not letting me put it back. So I'm just going to put,
Maybe Elizabeth wouldn't mind saying again what she was going to propose.
I'll try. That LDAs with at least 4 years of experience working alongside with an attorney who's willing to sign off on that attorney supervision.
And
alongside or under the supervision of?
Under the supervision is what you said the first time.
Yes, under the supervision of an attorney.
Wouldn't we want it to match what we've done for the others?
And Kim has her hand up.
I just want to say, listening to all of this back and forth, the one thing is the experience that they're getting now under the supervision of an attorney is not in the things that they're going to be doing. It's in their limited roles right now as LDAs. And so from my perspective, in thinking about this, that's the one concern I have, is you can sign off that they have this experience, but what experience is it that you're actually signing off that they have? Is it going to be the full scope of what we're going to actually be licensing them for? And if the answer to that is yes, which I don't think that it is, then I would have concerns of waiving that experience and the requirements for that training from my perspective.
Can I thank you, Kim, for raising that? And something I've been thinking in my head was, if the LDA has experience in that subject matter, but maybe not as an advocate, but they've been supervised and they otherwise meet the requirements, to me, it was sort of akin to the fact that when I became a judge, I had, experience in the subject matter, but I had no experience being a judge. But I got training and I learned that. And so I'm wondering if this is somewhat sort of relatable, that maybe an LDA would have experience in the subject matter, as Ms. Grijalva said, working in family law, preparing the forms, knowing what is or isn't required, and then would go through some of the training that's otherwise required to learn how to speak to clients, to issue spot. Because I think people are able to learn, and so that's sort of my question.
Just to my point, the issue is more that they're going to be learning this as they go along. Nobody's going to be there to really teach them other than by practice, right? Because there's no one there to oversee them then, because we'd be licensing them.
Kim and Judge Yu, I'm just wondering, just sort of in the interest of time, if you don't agree with the proposal, you could not vote for it or the motion couldn't go forward, just to see if we can kind of advance this one.
That's what I was hoping for. Thank
Would it
you.
help to add law-related experience? To Kim's point, like, we want to make sure that it's legal specific, it's relevant.
Judge Harper has his hand up, Julia.
Thank you.
I was just going to ask, the 4 years seems just sort of ambiguous. I don't know if is there some evidentiary information about 4 years? You know, Mr.
Well,
Hall-
and I'm going to chime in on that as well, because 4 years, what does that mean? Is that 40 hours a week? Is that, you know, with other things, we've done numbers of hours rather than days or weeks or months or years, because I don't know how that would be interpreted.
I agree. You know, Ms. Grijalva talked about people who've been doing LDAs for 10 years, 20 years. That's a different person than someone who's been doing 4 years filling out forms. So
The 4 years is just because we want that experience to be recent, so that it's consistent with the work that is needed today, evictions, you know, that's what, but we can say for 4 years or 1,000 hours.
Well, well,
The way it's written, couldn't it be that if they have 4 hours of experience, 4 years of experience, then they would use the specific hours and the attorney would have to certify the number of hours they have working. It wouldn't necessarily be that they get 4 years worth of hours.
well, that's the point. This is not clear. We don't know what this means. Like, if you were to give me this and tell me, what does this mean, 4 years of experience, I could not tell you what that, I would presume that it means 4 full years, full time. But I'm not sure. And whether that, you know, the 4 years could have been over the course of the last 25 years. It's not clear. The only way to make it clear is to say a certain number of hours within a certain number of years. That's the only way to get clarity around it. Stephen?
Can I respectfully suggest that, Judge, you withdraw your motion so I can make a motion without this amendment? Because we can at least get a read. People know that this is an issue and they'll vote no on the unamended version if they want to make this change. And then that way we don't have to get into the specifics of the amendment if we get a consensus that it's approved without it.
That's good. And if we could save that language, and I was going to say this motion that I had just made was maybe dying for lack of a second, but I will withdraw my motion.
Thank you. So I'd make a motion that we adopt the resolution on the screen with the understanding that
The resolution on the screen has a semicolon at the end of it. So let's make sure that it looks like how it's supposed to.
Thank you.
Okay.
With the understanding that if you want to adopt the modification that has been suggested by Elizabeth and Erica, you would vote no on this motion.
I'll second that.
Linda, did you get that? Amos is the second.
Yes.
So I
Are
think,
we ready to take a vote?
yeah.
Okay. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
No.
Hamilton,
Yes.
Judge Harper,
yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
No,
Judge Rubin.
I think he had to step away. Oh,
Okay. Yeah. Shining,
No.
Sarouche,
Yes.
Spyro,
I abstain, I'm not sure.
Judge Yu.
My vote is no. Thanks, Linda.
Okay, looks like we've got 1, 2, 3, 4, 5, 6, 7, 8 in favor. And 4 abstention, 4 no, and 1 abstention. So it looks like the motion carries.
thanks everyone.
Right. So I think we're going to move on to general civil. Carolyn, is it accurate that you do not want to present the recommendation of the subcommittee, although you are the chair? because if not, I've called upon Stephen Fleischman in the past. He's not here. So I didn't ask you, Amos, but you did provide quite a bit of edits to the memo. So I was thinking I would ask Amos.
Oh,
If
yeah, no, go ahead. I think that would be appropriate.
are you
sure.
comfortable doing that, Amos?
Yeah, I
Sorry.
can do that. That's okay.
All right, thanks.
Surprise, you're on.
All right. So the Consumer Debt and General Civil Subcommittee previously made recommendations at it was the April 19th meeting. We had 5 recommendations. 2 of them were voted on and passed, and 3 of them were held for further discussion. Specifically on the screen, the consumer debt subtopic and the creditor harassment, those resolutions were adopted on April 19th. And there were 3 others that we wanted to have further consideration of. It was wage garnishment, utility shutoff, and enforcement of judgments. So we did further consider. There was a lot of discussion at the last working group meeting, actually the April 19th working group meeting, about our recommendation to exclude wage garnishment. So we did revisit whether wage garnishments should be excluded. We did hear from people and had further discussion, and we changed our recommendation. So we are withdrawing our prior recommendation to exclude wage garnishments. We did have some discussion of whether we needed a resolution about that, but we decided that by not having a recommended resolution, that wage garnishment would just be included under the previous resolutions that's on the screen, the consumer debt and creditor harassment, that those would include wage garnishment because we're not excluding them. Leah, does that sufficiently, there was a lot, I didn't prepare for this, but at least on wage garnishment, I think that is my recollection of our summaries. We are just withdrawing our recommendation on excluding wage garnishments. Let me go on to utility shutoff. Similarly, at the April working group meeting, there was some concerns about our prior recommendation to exclude utility shutoffs. And we did revisit that as well, and also decided to withdraw the recommendation to exclude utility shutoffs. So again, we don't have a new resolution on this one either. The idea would be utility shutoffs would just be one example of a debt or a creditor-debtor relationship that would be included because we're not expressly excluding it. On enforcement of judgments, well, let me see. So going by the slide, 2 additional things that we considered. For consumer debt and creditor harassment, previous recommendations and resolutions, we had further discussion to amend our the prior resolution, specifically on creditor harassment. The discussion was creditor harassment might be unintentionally too narrow. We want it to be broader to include creditor-debtor issues that might not technically be considered creditor harassment. So we wanted to revise our prior recommendation, or I think technically what we're doing is we're proposing a new resolution that would replace the old one. And the main change for that is it's not just creditor harassment, it's consumer debt and creditor harassment would be the definition of what's included in the program with the same exclusion. So it would exclude all superior court litigation. This is all pre-litigation cease and desist and prove up letters and pre-litigation negotiation of settlements, including payment plans, would be included for both creditor harassment and consumer debt matters. And finally, we do have a new proposed resolution on enforcement of judgments. It's slightly modified from what we proposed last time. What we proposed last time was not voted on. And it's effectively the same thing, except we did have a minor change. So I don't know if that can be put on the screen of what our resolutions are. So we have two resolutions. One is replacing one of the prior ones, and one is a new one. So the first one on the screen would replace, the only changes are in the second line where it says consumer debt and creditor harassment activities. The prior resolution does not include the consumer debt and it's just creditor harassment. So we're just clarifying that that was unintentionally maybe too narrow. I think we added the natural persons as well on behalf of natural persons.
Right.
But what's included and what's excluded is all the same as before. And for the second resolution, this is a new resolution about enforcement of judgment, similar to our prior that we just never voted on. And the idea here is that we do recommend that legal paraprofessionals may represent natural persons in enforcement of small claims court judgments and represent natural persons in limited jurisdiction post-judgment enforcement proceedings.
So is there a motion for this? And then we can see if there's discussion.
Dana, I move approval of this resolution.
And by this, are we referring to the top 2/3 or the whole thing? That was highlighted currently?
These are the new changes, correct?
Right.
Yes. Yes.
So just, go ahead.
I'll second the motion.
And just to clarify, this is intended to replace the prior resolution on the same topic.
Carolyn?
So just, this is better, but I just still couldn't full-heartedly get behind it because as we heard from some of my colleagues, you're basically just letting someone stand in the hallway and negotiate a debt payment. And that just really isn't what we want. And further, like today, as we talked about regulation and all the warnings under, I think it was 1.4.2, where's that going to be to tell someone specifically that they may have a class action? I think we talked about this, they may have a much bigger lawsuit on behalf of all of the people who are having problems with regard to the same kind of credit card debt, for example. So that's why I couldn't get behind it. I wrote a minority report. I really don't need to elaborate on it anymore, I don't think. So these are things that are good. These are things that are good. And this was much better than what we had. But I still can't full-throatedly say it's really what we want to do to stand up this program without making it so difficult for people to understand it. It just, there you go. I'm sorry. I'm soapbox again. I'm over.
I don't see more hands. So Linda, could you please take the vote?
Bashan,
Yes.
Arnoldson,
Yes.
Falmouth,
Yes.
Hamilton,
Well,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Yu.
yes. Thanks, Linda.
Motion carries.
And I always like that Judge Yu goes last by virtue of the alphabet because she always thanks Linda for all of us at the end of it. Okay, Amos, the second resolution on here, do you want to talk about?
Yeah, so this is the one for enforcement of judgment. So this is not replacing an old one. We just held it back to consider it further. And it was slightly amended from our prior recommendation because we're allowing licensed paraprofessionals to represent natural persons both in enforcement of small claims court judgments and limited jurisdiction judgments. And that, by the way, is on behalf of either side, creditor or debtor. It's just the limitation is to natural persons for enforcement of judgment proceedings.
So moved.
All right, so that's moved by Judge Yu. Do we have a second?
I'll second it, Harper.
And Judge, it's the double judge motion. Further conversation, Carolyn?
Okay. Very, very quickly, again, the reason we discussed natural persons, which is small companies and businesses who might owe each other in a fight, over $10,000, $15,000. And again, that's a good thing. However, it's not so limited. And so it's really.
Well, I just want to be clear that we're talking about small claims court judgments and limited jurisdiction proceedings.
Right. That's okay. It's a slippery slope and it's natural persons, and that is not what we were intending to do.
So, I'm sorry if I'm confused. What did you think the intent was other than natural persons?
To help, people who are individuals, low income, who are being harassed, unable to find representation for these kinds of amounts.
Okay. Other comment, question, discussion? Not seeing any. Linda, if you could please take the vote.
Bashan,
Yes.
Bernelson,
Yes.
Belmeth,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hardston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Yu.
Yes, and thank you from all of us, Linda.
Okay, the motion carries.
All right.
What next?
I believe it is family law.
Yes.
Let me just bring that up.
And you know what? Since we have been going, close to it's 2:53. Let's take a 5-minute. I'll call it a sanity break, and resume at 3 o'clock with family. Okay.
Okay.
Thank you.
Okay. Once we have Linda back and Leah, we'll get started again.
I'm here.
Okay.
I'm here too.
So we've got a couple of folks that we're waiting on. Who's leading the discussion on family?
I am, Your Honor.
Okay, Fariba, let's, I just want to make sure we have enough, that we're not waiting on too many folks here. Okay, why don't you go ahead, Fariba? And does Linda have slides that you'd like to have put up?
Yes, there's just one. So the only subtopic left for discussion today on today's agenda is conservatorship and guardianship. And I want to start by addressing the public comment that was made earlier with regards to mixing up probate into the family law subtopic. I think that was the way the study was conducted originally, and the name was actually changed to say family, children, custody, but that doesn't necessarily mean conservatorship. So I understand. But with regards to like a surprise, it sounded like we hadn't publicized the topics of discussion. And the fact of the matter is all these meetings are public. They're posted ahead of time. And I'm sure the rest of my subcommittee, we welcome public comments, we welcome input because we want our proposals to be informed. I want to remind everybody, including members of the public that are still with us, we have the issue of dependency or child welfare on the agenda at our meeting on the 29th next week, and also any remaining family law issues. So I do welcome those who are interested to sign on and make their comments known during our public comment segment. So today's, could you put the a resolution up, Linda, please?
Yes, I will do that.
Thank you so much. Thank you. We received, before I asked for a motion or make the motion myself, we received a public comment in form of a letter from Private Defender Program, San Mateo County Bar Association, just opposing including this issue as a task, an issue that can be handled by paraprofessionals. And reading their letter, it just seems like they believe that we are authorizing representation for proposed conservatees. And the fact of the matter is that we're not. So reading that, I was wondering to myself whether we need to actually make that really clear here. Second line, authorized to assist parties, maybe change parties to proposed conservators or petitioners to make it really clear that conservatees are not included here. For the most part, because they're going to get court-appointed counsel if there's an objection to the application in the conservatorships. But because I see that because we've mixed guardianships and conservatorships, we have to talk about petitioners or applicants rather than proposed conservators or proposed guardians. So anyway, that's what I wanted to mention. The letter also talks about LPS conservatorships, and LPS conservatorships are basically mental health conservatorships addressing a person who has a specific mental health disorder from the DSM list, such as schizophrenia. There is a major presence by the public guardian's office. As a matter of fact, the public guardian becomes the temporary conservator when an application is filed, but an application can be filed by a relative. So a relative can become ultimately the long-term conservator, the public guardian's office, or a private professional conservator. But because of the huge presence of the public guardian as both the temporary conservator and the investigator, just like the regular conservatorships and guardianships, huge presence of the court investigator's office, is that the chances of a conservatee somehow being impacted here negatively by the work of the paraprofessional is very minimal. Plus, there are a lot of self-represented litigants right now in those courts. I know we help with those forms. They're very form intensive, just like adoptions. So I would still be very comfortable in putting forth this resolution with the minor change that I'm recommending in the language. So Justice Petra, would you prefer that the motion is made and seconded before discussion?
Yeah, I think that's a good idea, so that we know what we're discussing.
Okay, I'm just gonna close my office door one moment.
Sure.
All right. Sorry. All right, so can you make that a little bigger? Is it my screen? Okay. So I move that the work group adopt the resolution as stated on the screen, the first resolution.
Okay, do we have a second?
I'll second. Erica seconds.
Yeah.
Okay, and any discussion? Amos, your hand is up.
Yeah, for discussion, I just wanted to note, at least from the memo, it looked like for the second part, and I realize that's not what the motion is about, but for the second part, I think it's relevant for the vote on the first, which it sounds like there is a split in the recommendation of the committee about whether or not in-court representation should be allowed. I don't know how many people are on the committee, but it looked like 3 people, including Ms. Sarouche, do not believe full in-court representation is allowed. So I understand we're dealing with these differently, but I did just want to make sure everyone realized that there is sort of this, and that might affect your decision, I think, on the first.
So is it your thought, Amos, that these, that they should not be considered separately because you don't know how to vote on the first without knowing the answer to the second? You're muted.
Thank you. I'm fine either way, but I just think it's relevant for people to know that there is this split in the recommendation on the second proposal. Sure. as we.
And so looking at the first proposal standing alone, it would be that the paraprofessionals be allowed to authorize petitioners in uncontested conservatorship and guardianship cases, except for independency court, for parties, of course, entitled to court-appointed counsel, but that does not say whether the representation would or would not include full in-court representation. Dana.
Before we go on, I just want to address Amos's comment.
Yeah.
I was one of the ones who favored the second resolution, and I've been thinking and rethinking my position every time I learn something new and I read the comments and I talk to experts. And because we're talking about uncontested guardianships and uncontested conservatorships, there's not going to be any litigation here, and the process is fairly simple. With regards to the litigation and advocacy piece, it's really all forms. So I would actually, and because of BK, I can't just call my colleagues on the committee and say, what do you think? So anyway, so I have to announce my change of heart here, and I don't want to surprise my committee members, but that's just the only way we can do it. I'm have good faith here. And just that saying that I'm now in favor of the further result on the screen.
And Dana?
I just want to clarify that there are 5 people on the subcommittee, and given what Fariba just said, if I'm understanding it, it would have been 4-1 in favor of in-court representation.
Fariba, is that an accurate summary?
Forgive me, I believe that Dana is right with her numbers, but I guess we'll have to wait and see when the vote is.
But the memo reported 3 people against.
I was one of the one against.
And I think Sharon, but I don't want to speak for you, Sharon.
Yeah, I was against.
Okay.
I'm sorry, yeah, 6 people. There are 6 people on the subcommittee.
And I'm too many subcommittees, so I lost count.
Yeah. understandably. Julia?
Okay, Julia?
Can you just tell me again how many are recommending which one? And
But we're not, and that's fine, we're gonna get there, but my understanding is we're not looking at that further resolved right now. Right now, the only motion on the table is whether the paraprofessional should be authorized to assist petitioners in uncontested conservatorship and guardianship cases, except for in dependency court where the parties are entitled to court-appointed counsel. So unless someone feels like we can't move forward with taking a vote on that, we have a motion and a second.
Okay, let's go.
Let's take the vote on that, and then we're going to come back to the further resolved and get more information for you and everyone else.
Any other questions before we, Ira?
Yeah, does the first resolved here mean, well, it seems to mean that the representation does not include full in-court representation, but it doesn't say that. Does it mean that because of one of our other resolutions?
I'm so sorry, I don't understand the question. Could you repeat that for me?
Okay, it says, the first resolve says that that we recommend paraprofessionals be authorized to assist petitioners in uncontested conservative guardianship.
Yes.
The second one says full court, full court.
Oh,
yeah,
no.
Full in court, wait. Full in court representation for both, for the same thing. Does the first one mean not full in court representation? It doesn't say that. Maybe it means that because of some other resolution we've passed, but I don't know.
Okay, Ira, let me help you out. Linda, could you go up and show the two further resolved versions just for a moment so I could show? The second one, the further resolved, the alternative is below that. So resolved, where's these two versions of the further resolved?
I didn't provide that. I could add that.
So in the memo, there are two
Sorry
versions
about
of
that.
the further result. One is this one, full in court representation. The second one is limited in court representation, limited to being at the table and answering direct questions from the judge. Okay. The first resolution doesn't have an alternative. That's just talking about forms, legal advice assistance in uncontested conservatorships and guardianships. Once there's an objection and it becomes litigated, it's no longer uncontested, then the paraprofessional has to step out because it's outside of their license, if this passes.
Right.
Well, and I will add that other language. I apologize for that. That's an oversight.
Well, I don't think we need it right now. Julia?
I just wanted to make a friendly amendment to somehow say be authorized to assist with forms or whatever it is the intention is that Ira was confused by, because assist is different than in-court representation, but it's rather vague. At least it was for me as well.
And that's fine. With all of our other resolutions, however, we did divide it into exactly what you see here. One is to help in the subject matter and one in court representation.
Okay.
We are going to, I do think though, for example, I could see well, all right, let me be quiet for now. Kimberly? You're muted.
I just want to be clear. Are we just voting on the first little section?
Yes, that's what I'm trying to get us focused on.
Okay.
And so we need to move the screen down, just the first one, but the confusion, what was just raised is just the first one standing alone does not exclude in-court representation. And so if that were the only thing in the universe that existed, then potentially it would cover in-court representation. I think before we are done with this subject this afternoon, we have to have a second resolution that makes it clear whether or not, or to what extent in-court representation is permitted. With that understanding that we are going to be doing that, can we take a vote on just the first resolved on here?
Okay. Bashan,
Yes.
Brynelson,
Yes.
Thomas,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes, excuse me, yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Yu.
Yes, thank you.
The motion carries.
Okay, so now we move into, it looks like there are two competing, and we'll have to see who actually moves for one of these. There's one further resolved about in-court representation, full in-court representation. There's another resolve, which would be to be able to sit. Again, we are talking solely about uncontested conservatorship and guardian cases, not contested. So
Justice Pitcher, just as a point of clarification, the first further resolved is the default position that the working group has.
sure.
Right. So,
Right, so if we do nothing further, that is what it will be.
Okay.
So I don't know that we actually need a further resolution on this, but since we've been having this conversation, I think that we need to have some clarity here. So
If we do need such a motion, I would move the first, which would be our default, that they be able to provide full in-court representation.
okay, and we will take discussion on this, but is there a second for the motion?
I'll second that.
Oh, go ahead, Judge.
All right, so the first was Judge Yu, the second was Judge Harper for full in-court representation in uncontested conservatorship and guardian cases, all right? Because I think it's very important that we keep in mind that we are not talking about contested matters. Now, I would love to have conversation on this. I think Amos, you had your hand up first.
Yeah, thank you. And sorry if I caused confusion by raising this earlier, but I did think it was important to raise. And I would like to hear from the subcommittee members who proposed this, because again, I think it was a split recommendation. And at least at the time of the memo, there were three subcommittee members who were proposing that we limit the in-court representation.
Okay, let's hear from the subcommittee members, and then we'll go to Carolyn and Dana.
So I'm actually on the subcommittee.
Go ahead, Dana.
Dana, go.
I just want to be really clear about what happened. It's not a split. It's a 6-member committee, subcommittee. The vote was 3-3. 3-3, a tie is no action, which leaves us with the default position of full in-court representation.
You've already heard from me. So Steve and Sharon and.
I could go. So mine position was the second resolution, and that was just based on my philosophical and unwavering belief that the in-court representation is problematic. So that was why I was making that recommendation. In the grand scheme of things, because we're limiting it to uncontested matters, is it going to be problematic to have the paraprofessional in the courtroom? Probably not.
Are there, let's go ahead and hear from the remainder of the subcommittee members.
Sharon and Elizabeth, do you have any? Oh, Elizabeth's hands is up. Elizabeth.
So I, of course, am always going to default to giving the paraprofessional more power in the courtroom. So I was one of the person who was promoting full in-court representation.
Thank you. Sorry.
No.
I was one of the people that was in favor of the second resolution. I didn't want to give full power to the paraprofessionals in these types of cases. Like, if you really think about these types of cases, conservatorships and guardianships, even if they're uncontested, and what's at stake, and then look at the amount of training that is required for a paraprofessional, I just don't think that really matches, what they do in law school. I don't think that it fully prepares someone. Clearly the Britney Spears case is in the media right now. In conservatorship, I think in the beginning, In her case, she didn't really speak up. I just think that these cases tend to be complicated just by the very nature of what we're talking about. And for that reason, I'd be in favor of having paraprofessionals there as support for the client and being able to respond to direct questions from the judge. But I don't think that it's appropriate for them to fully advocate on behalf of their clients.
And can I make a quick observation? In one meeting, we were able to discuss not only Britney Spears, but Kim Kardashian.
Okay, any other, I think we heard from all committee members, Your Honor.
Yeah, Carolyn, what celebrity would you like to discuss?
That's right. Yeah, not Kanye West. Okay. I've done these quite a few times, and Beth Zedek has a wonderful clinic at LA County, although I don't know what's happening in Zoom land, but they have a wonderful clinic once a month, and that could use support. That could use more funding, more money. It's a fantastic clinic. They walk everybody through these. The idea that they're uncontested guardianships is really a difficult one to really find one. You have to notify all the family members and the grandchildren. It's extremely rare to find these as uncontested. And they get PVPs, which is now court-appointed counsel. So, which are highly trained and appointed by a judge when he sees an issue. So what this area needs is really more support of existing self-help. And again, the language is tough. The opposition from the community that we've started to see, this is a brand new thing that has not been highly publicized, and we haven't heard from the trust and estates community on this. There's a lot at stake. There's freedoms and liberties at stake. There's mental health challenges at stake. There's doctors' opinions that need to be obtained. We have a healthy probate system in Los Angeles County. It needs more funding with regard to this. It's in place. It's done. Maybe in other counties that's not true. I'd love to hear about the smaller counties and how they do this and get rid of it. But the need is great. It's there. The help is already there. So this is an area that you haven't. And
I'm going to ask Leah to jump in for just a second. You made a statement, kind of a blanket statement, Carolyn, about not having heard from the estates and trust community. I don't think that's accurate, but I don't want to speak out of turn or be incorrect. And I'm going to trust Leah more than myself on the recollection.
Yeah, I don't think it's accurate either. And members of the subcommittee may want to jump in, but there were a number of instances, not just from public comment, but where practitioners were consulted to facilitate the development of the recommendations.
Right, and I should have mentioned that in the beginning, Your Honor, that one of the other comments was that we don't have experts on the subcommittee. Well, for whatever topic we didn't have experts, we reached out. I believe on this issue, we consulted no less than 6 experts. Steve Hamilton brought somebody. I have 3 experts in my office. I brought in 2 court attorneys, as late as this morning, I consulted an expert regarding the letter we received. So no, we have actually consulted, and I think, in my opinion, sufficiently. And again, public meetings, everybody could come and comment, and unfortunately, we didn't get a lot of comments at the family law subcommittee meetings. I believe Elizabeth is first, Julia is second, and Sharon is third. Go ahead.
I just wanted to say I don't do guardianships or conservatorships, and so I was listening very carefully when we did have those experts come in and talk to us. We heard from our very own working group members where they see guardianships, uncontested guardianships, as being grandma trying to get custody of a child who was abandoned by their parents or in custody in jail, that kind of thing. So that's uncontested guardianships. Also, I've been reached out from the public directly where you have some people who need these services, but I've had people come to me and say, can you help me fill out this questionnaire I want to get conservatorship for my child. I went to an attorney, he gave me this questionnaire, I can't even fill this out. So the need is there for the assistance. And here in San Francisco, I'm not again, I don't do this, so I'm not familiar with how much service these people have. But because Betts Legal is in LA and has a great program, it's not transferring here to the Bay Area, to Sacramento, to the places that really need it, where there's language barriers, where there's access to those workshops, there's lack of access to those computers to be able to even go onto a Zoom meeting. So, you know, the people need help. That's all I want to say. Thank you.
Thank you, Elizabeth. Julia?
I was just wondering, is there any of our judge colleagues that are here that could tell us about what this entails, since this is not an area of my expertise? Could we have contributions from some of our judge friends?
Trying to think who's most likely to have
What
dealt.
do you mean what this entails? I mean,
Yeah.
what do you mean? So we have a significant amount of guardianship cases that are unrepresented. It's exactly as you just described, a grandparent trying to get guardianship of a grandchild, and they're trying to fill forms out on their own. They're coming to court on their own. They really don't know what to do. And so this, you know, from my perspective, it'd be really helpful to have professionals sitting there helping them, being able to advocate for them in court, their position. Again, this is uncontested. This is just something that they're just going to be there by themselves, or they have someone there to help them. It'd be nice to have someone there to help them for sure.
So Judge Harper, what you're saying is then the full in-court representation, you feel that it would assist you in hearing these cases?
Absolutely, yeah.
Thank you.
And it's not just that, there's follow-up reviews that have to happen as well that come a year or 2 years later. And so a lot of people don't understand they have to do that. They have to fill out paperwork for that. And these paraprofessionals will be able to help with the follow-up to make sure that these kids are safe and that things are happening. This is for conservatorships as well, that they have to do follow-up review hearings. And this would help people understand how to fill out that paperwork as well.
Thanks, Judge. Judge, you?
I agree completely with everything Judge Harper said.
Yeah, and I used to litigate when my litigation days, I litigated guardianships and I did a lot of unrepresented. Honestly, the hearing back then, maybe it's changed now, but the hearing uncontested, like 15 minutes or less. We're in, we're out. It's nothing major. Sharon.
The only thing I'm going to add is that when we did talk to experts, it did seem like there was an amount of expertise, even in these cases. Like it's not general attorneys that are doing these cases. These are probate attorneys. And I've run pro bono programs for years. And even like I used to run a guardianship pro bono program. And even in those cases where you would have attorney X from X firm that was like a corporate attorney that wanted to help a child in need, in those cases, it was heavily supervised by an expert that sometimes even went into court with them and helped them. So, you know, there was a great amount of hand-holding in that. So I would just take that into consideration. And again, hold this up against the educational and experiential requirements. And ask yourself whether, like, I think it's a slippery slope, and that's just where I stand.
And thank you, Sharon. Any other comments? I do not see any other hands. Could you call the vote, Linda, please?
Yes. Bashan,
No.
Bernelson,
Yes, thank you, Linda.
Spellman,
Yes.
Hamilton,
No.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Shining,
No.
Sarush,
Yes.
Spyro,
Yes.
Judge Yu.
Yes, thank
The
you.
motion- The motion carries.
All right. Thank you. I think that's it for me, right?
So,
Reba, do we want to address the minors council issue today or wait until we discuss it at our meeting next week?
Yeah, we'll discuss it on the 29th and bring it back.
Okay.
Thank you. Thanks, everybody.
Okay, so where are we now? We've done pilot already. Governance.
Yep, and Linda is going to walk us through this. And again, this is just for discussion and feedback.
Although I do think, I know Linda will walk us through what it is, but I do think, Leah, it would be helpful for you to provide the group some background about, I mean, you and I have had the discussion about the fact that there's not that much for us to discuss, that there's some, structural things in place that we need to pay attention to. So I think whether you want to do that now or after Linda goes over this, it's important to do.
Okay, let me let Linda go through and then see what she didn't cover.
Okay, so as the memo that I wrote describes, there's an extensive table that goes into detail about the different governance functions for the program. And these are the broad categories in terms of who has the authority to make decisions on these different topics. So obviously the Supreme Court has to approve the program. The Supreme Court has authority over anybody who's licensed to practice law, and the Supreme Court would need to approve any rules that are developed, both state bar rules and the rules of professional conduct and the rules of court. The legislature would need to, again, approve the program as a whole in concept and enact the required statutes, including those that Brady discussed earlier. And then in terms of the oversight committee, as I discussed in the memo, we're moving away from this term board. In terms of the state bar structure, we have one board of trustees, and any other of the entities below that are committees and commissions. And so the proposed name is this paraprofessional, although the word paraprofessional presumably would be swapped out with whatever name is decided, a licensing and oversight committee. And that committee would be charged with the direct oversight of the program operations and reviewing of the licensing regulation and disciplinary activities. This is where changes to the program that come along would be handled, and things would only be escalated to the Board of Trustees if their input is needed. But the presumption is that the board, even though this is a program of the bar, of the state bar as a whole, that the state bar would delegate the most of the functioning of the program to this paraprofessional licensing and oversight committee. One thing I do want to call out is the disciplinary structure that was adopted by the working group includes having the disciplinary authority be handled by the licensing and oversight committee rather than going to state bar court. So are there any questions on this, the governance functions? Amos.
I have some questions. Your original memo, your December 17th memo, recommended that it be a board or committee of 13 people. That has been reduced to 7. And that includes a reduction of the number of paraprofessionals from 5 to 1. I'm wondering, and it did discuss that a little bit. It looks like from your memos that the original memo was based more on what other licensing boards, how they're structured, because there are a number of licensing boards in California and in other states. And it looks like, Linda, you did some canvassing to figure that out and to try to make something parallel. It looks like the recommendation to reduce that came internally from the bar, from bar staff or bar leadership. Can you talk a little bit about that reduction?
Well, part of it came from, at the meeting in December, there was some discussion among members of the working group that this oversight committee should be smaller, that it didn't need to be 13 people. And in addition to that, the state bar adopted as part of a broad review that was done of all of the state bar sub-entities. The board adopted a policy that these sub-entity oversight committees should not exceed 7 members unless there was a demonstrated need for it. So this aligns with that policy that was adopted by the Board of Trustees.
So that makes total sense, that there is sort of this rule of thumb or default rule for 7-member sub-entities of the bar unless there's a reason why. I would be interested in exploring if there's a reason why we should have more paraprofessionals, more than one paraprofessional on this board, consistent with other licensing boards. So my recommendation is that the regulation subcommittee consider this further. We have Kim Kirschmeyer, who's very experienced in other boards, and we could obviously hear from other people. But that would be it sounds like this is the bar's recommendation to follow its default rule for the size. And I think I would like the working group, either through subcommittee or the full working group, to at least consider if this committee should be more parallel with other similar licensing boards.
Julia?
Yeah, it looks like to me it does look pretty sparse. I guess what I'm asking is when it says, okay, so the Board of Trustees is going to appoint an attorney, a paraprofessional. So I don't know how that selection process would exactly happen on a new profession without having a paraprofessional. So to me, it doesn't quite make sense that in the original formation, you'd already be without one member because we're not going to have any paraprofessionals to appoint yet. So that is something I'd like to bring to their attention. Then where it says paraprofessional educator, are you saying that the California Board of Community Colleges or California Law Schools with paraprofessional program is going to nominate one person?
Yes, that's the intent.
I think that's going to be very problematic. They're two very different types of educational entities. And I think if you want, I think it's going to be very important to have somebody who's an educator that's working in this or has been a part of this. And I can never see that a law school is going to give up their pick to a community college educator.
Well, one way you could resolve that is it could be on a rotational basis. One term it's the community colleges get an appointment, another term it's the law schools. So I think there's ways to address that particular issue. They don't have to jointly agree, is what I'm saying, on who should fill the slot.
And again, Leah, why is the number 6 the magic number for a committee?
The number 7, there's a very extensive report that was done on this in 2017 and submitted to the board. There's lots of research on the functioning of groups and group size. So okay. That was the reason for that position. I do think, and this goes to something I think Justice Patru wanted me to speak to, there is a lot of bases for the division of responsibilities that you see in the memo between the committee, the Board of Trustees, the Supreme Court, and the legislature. That's really grounded in, again, much of this work that was done in 2017 to try to clarify and make sense of the decision-making structures at the state bar vis-a-vis its own regulatory authorities. But also to ensure some consistency in thinking about this new oversight committee, ensuring that its responsibilities and reporting lines were somewhat consistent with other entities at the bar, for example, the Committee of Bar Examiners. So when Justice Patru indicated that we don't have a lot of leeway here, there is a great deal of rationale, I think, behind that division of labor. With respect to the size and the composition of the appointees, I feel they're a little bit more comfortable that we can, certainly based on your input and desire, recommend a deviation from the default position. I don't think that would be as problematic as a radical restructure of the alignment of responsibilities, if I'm making sense. I do see a couple other hands up. Kim?
Thank you, Leah. Just from experience with boards, I think 7 is going to be a tough one for this board in particular because you're voting on disciplinary cases and you have several that are appointed. And I mean, hopefully we always hope, at least on our side at DCA, we always hope we get appointments timely. But that does not happen. You have changes in administration and they're working on other things. You have changes in pro tem, changes in the Speaker of the Assembly, and those don't come in. And for this particular board, if you had those 3 entities without a appointment, you're already at 4, which is going to be your quorum, and setting meetings and getting that many individuals to vote on these disciplinary cases could be problematic. And so 7, while I totally understand getting work done, and 7 is probably a good number for that, sometimes meeting quorum is definitely a difficulty that we have for our small boards. And we have different appointing authorities as well. So that's one thing, just the size. I think this is different than your other committees because they are actually determining discipline on a new licensing group. And you can, as far as paraprofessionals, I think it's quite frankly woefully underrepresented of paraprofessionals. I think that to have a paraprofessional committee with 1 paraprofessional basically on it, I think that doesn't represent that licensing population at all. And I think that down the road that could cause problems for the bar. And I think as far as getting individuals, to Julia's point, getting individuals on, you always want to stagger appointments anyway. So you can, have it so many people that you already have, like your attorney, your judge, and public. And then as those individuals get licensed, you can bring individuals on. So that's just looking at this and the memo and everything. Those are kind of some of my suggestions, recommendations.
Thank you. Ira?
I think the subcommittee should consider having a paraprofessional or non-lawyer group appoint the paraprofessionals. Now, as somebody pointed out, there aren't any paraprofessionals when we begin, but there could be a proxy for that, like this California Alliance of Paralegal Associations. It's the Board of Trustees who's designated now, and for the paraprofessional appointments, and that board is by law or rule a majority attorneys, and I don't think that's the best. I'd like to see. Well, you know where I'm going.
So Ira, you'd like to see more paraprofessionals and paraprofessionals not appointed by the Board of Trustees?
No, I guess it wasn't clear where I was going. I would like to see the paraprofessionals appointed by an organization of paraprofessionals, or to begin with, paralegals or some other kind of non-lawyer legal workers.
Right, okay, I got it. Judge Yu?
I think Kim really eloquently said much of what I wanted to say, so I only have 2 additional points, which is maybe there could be some interim rule that for the first iteration, because we don't have paraprofessionals in California, someone out of state might be able to sit. But I think there should be at least 2 paraprofessionals, because the Northern California and Southern California interests seem to not always be the same, and the populations are different. So I think it would be really important to have both perspectives represented through the paraprofessionals who are actually doing the work.
Okay. Amos?
So I agree with what Justice Yu and Kimberly are saying. I did have one, and that's with the size of the board, the number of paraprofessionals on the board, the appointees. And again, I'm happy for the regulation subcommittee, if you like, to look at this. We have not looked at this as a committee. I did have one question on the split of authorities. It all did seem to make sense to me. I did have one question about the hearing panel selection. It looked like the hearing panel selection, which I understand would be the disciplinary function, is recommended by the committee to the Board of Trustees of the bar. And I'm wondering why that wouldn't be a function of the paraprofessional committee.
I think it's a question. It's a good question, because the hearing panel is slated to be compensated, which is very different than any other construction that we have at the state bar. I thought that at least initially, those folks should go to the board. But that is not one that sort of was structured to mirror something else already in place, because we don't have that in place. So I think it was simply the fiscal implication, the fact that it will be very new to have paid hearing officers.
So again, I haven't really thought that through, but that was a surprise to me. And that is something that I would have assumed would be with the paraprofessional committee. So I think that's something that we might want to look at a little further.
Okay. Anybody?
Any more comments, thoughts, input? I mean, this is a discussion item. Okay, Leah, do you have anything else on this?
No, I think we will, you and I should talk about how to move it forward, but I think we got great feedback today, and we can certainly make these modifications.
Okay, so then let's put up the licensee name, which of course we were never going to reach consensus on, but we move forward. You know, I'm not going to belabor the point, we've talked about this somewhat before. We did, you know, Leah and I met with a pro namer. We came up with an initial longer list, which there was extensive feedback to based on that, and some further considerations like what's the acronym. We had a winnowed down list that we sent out. 13 of the 19 working group members responded to that second survey. And do we have the results that we can put up?
Oh, yes. Sorry. Well, is it not showing right now?
Well, yeah, but I mean,
the more detailed results?
Yeah.
Okay.
While Linda's doing that, Ira, did you mean to have your hand up again?
Yeah, I did.
Okay, go ahead.
Okay. Somebody pointed out a couple hours ago, public comment, that we've got to try and avoid misuse of the words when they're translated into another language. And then I realized, I think I voted myself for the word licensed with a D at the end, passed. And somebody who knows Spanish better than me could correct me, but I believe licensed translates to licenciado in Spanish. And that exact word in Spanish also means lawyer.
Yep.
So that is, it could be a problem, I think.
That is.
Yeah, you know, the naming thing is very difficult, right? Because, you know, we initially had a lot of things with certified, which many people came back appropriately to say they're not certified. They don't get a certification. They're licensed. So that's not an appropriate word to use. So yeah, I mean, this has not been an easy process, but that's a very good point, Ira.
Authorized came to mind.
Okay, Stephen.
So any of the recommendations that end up in the acronym CLA are problematic for my group, the California Lawyers Association, because of the acronym that's going to be used. And it'll probably get you a lawsuit from the California Lawyers for the Arts, because that's what happened to us 3 years ago. So
that's a good warning.
I'm really asking that we steer away from any acronym that results in the initial CLA.
Yeah, and with the words that we were using, we had a lot of things that wound up with an LLC or LLP, which has, you know, obvious problems.
Julia,
yeah.
The only other thing I was going to say is yes to Ira, the licenciados in Spanish. But the other thing is, I just think we should also make sure that we're clear that the acronym doesn't sound too much like an LDA. So I think knowing that paralegals are called paralegals, LDAs really use that more than, I don't hear anyone saying the full title of their name anymore.
Sure.
So I anticipate the acronym is probably going to even be more important than the words.
Right, which is why, you know, on the second go round, I pointed out that like we really want to stay away from the LLPs and the LLCs. Yeah. And Stephen's telling us to stay away from, although CLA didn't make it into the last round, so I think we're okay on that.
I'm seeing that now. So I apologize for interjecting on this.
It did make it into this last round, but it says LLA and it should say CLA, that last
Yeah,
one.
but that got the lowest number of votes. That one's not going to move forward. So we're okay. Ira. No?
No.
Okay, because your hand's up. Fariba?
With regards to language access or translation, sometimes there's no literal translation and we'll just have to go with the best translation. So in Farsi, there's no literal translation of paralegal. So it's more of a descriptive term rather than a term like paralegal. So I'm sure we can, I'm not sure, I should say, I'm not sure if we can do that, but I was just going to put it out.
Right. And just so you know, before we take more comment, what Leanne and I have discussed is not putting forward one name as a recommendation, but putting forward the top, most likely the top three, which at this point are the triple LP, the certified legal practitioner CLP, and the licensed legal advisor LLA, maybe not. So I don't think we're going to put forward one. There's not one clear winner per se, but there are dozens that have been winnowed out by through the course of this. Stephen, did you have something else to say?
No, forgot to lower my hand. My apologies.
Okay, Julia?
Yeah, the only thing I was going to say is when I'm thinking, because I am bilingual in Spanish, I don't even know that practitioner is going to translate very well. The one thing I think is a word that, and I don't, advisor almost sounds like a lawyer, but I was just going to maybe say instead to keep the triple LP, instead have it limited license legal professional. So that I think the word professional translates very well into many languages. That's just my 2 cents.
Okay, so your suggestion is limited license legal professional?
Yes.
Okay. I'll see if there are other people that want to comment on that after we hear from Amos.
So I don't like any of these names. So that's sort of the perspective.
What do you like?
So first, let me say my concern. My concern is the use of certified, the use of licensed have problems. And we had public comment at the beginning of this from some legal advocates, from legal services advocates that have seen problems in this area before about fraud, about misuse of the name. And I think we need to really consider those issues. So what was suggested by public comment earlier was limited legal advocate. I also like, besides advocate, practitioner or professional or advisor. But I think we just started this process wrong by having a lot or many of the options being licensed or certified and not hearing about those concerns.
We had a lot of options on the first go round that did not include certified or licensed, which generated a lot of commentary about the lack of putting that in there. Yes. We actually had, Leah, correct me if I'm wrong, on the first round, quite a few that didn't have it. And a number of people wrote back saying, no, we want to make it clear. Am I hallucinating, Leah?
No, there were really strong feelings about having licensed or certified.
So what I meant to say, you are correct, Justice Pistor. What I meant to say is from the public. So the way this went was sort of surveys of working group members, and what we haven't done is really hear from the public, from legal advocates, from consumer advocates, about the concerns of the names and using those. And that's where I think I'm very hesitant that we push through some of these just from our internal surveys without really having that public feedback and really consideration of the concerns.
Does anyone in the group have any insight into, Leah, I'm looking at you, or Kimberly, look, I simply don't know, okay? When there has been the creation of a group of professionals, what the naming process historically has been, for example, out for public comment, right? Things like that. I don't know if there is a standard way that this is done.
I have never done it before. And I feel like our expert professional might be able to give us some guidance as to, you know, quote unquote market testing that is probably typically done in her world. So I
Although,
don't,
you know, although her world, you know, to be fair, like those professionals tend to be dealing more with business names and with products. And so they're certainly, you know, well equipped to talk about like market, but this is a bit of a different universe that we're in.
right.
Carolyn?
Yeah.
Oh, very quickly, what was wrong with paraprofessional?
People did not, I mean, that was part of the initial too. People did not like the words that started with para, because to many people, it sounds like a para something is something like fake, or, I mean, I don't want to put words in people's mouths, but people did comment on that. Fariba?
So another issue for me here is none of these names clearly say that this person is not an attorney. Like certified law student is very clear. This person is a law student. And originally I had thoughts about having the non-attorney, having as a name, non-attorney advisor or non-attorney legal practitioner, something very clear that this person is not an attorney. I think these are vague in that sense.
So you're talking about something like like having someone that's called a non-attorney legal advisor?
Non-attorney, or somehow in the name make it really clear that this is not an attorney. And one of the suggestions I had was non-attorney, and then add any of these to it: legal practitioner, legal advisor, legal consultant.
Okay, Julia?
I like Fariba's suggestion. I think it's one of the clearest indicators thus far. I don't know how negatives are for marketers, but I think for the consumer, it is very, for the consumer, it's about the best bright line one can make. The only other thing I would suggest is, have you spoken to how they did it in Arizona, Utah, and Washington, how they came up with their names? Maybe they could shed some light on this.
I have, I would say we are going through a more scientific process than what I understand occurred.
Okay, good job, California.
Elizabeth?
Thank you. So I did a Google search, and advocate translates to defensora, so like the defender. If we use the word advocate in one of the titles, if we use the word advisor, we get asesor. So essentially, in Spanish, it's an assessment, and people come to me and they want an assessment of their case. I don't give legal advice, but in this case, so just maybe the word. That's all I wanted to contribute.
Okay, thank you. Amos?
I just wanted to voice my agreement with what Fariba said as well. I think another way to do it besides non-attorney is using the word limited. So limited legal advocate, advisor, professional would also work for me.
Sorry, I want to be quite clear, because it's very, and I don't mean to put anyone down by saying this, it's very easy to throw words out and very difficult to actually come up with a title. So for example, you just said like limited, you just used 4 words together that I've already, my fault, forgotten.
So to be clear, limited legal is the first part. And for the third word, I would be fine with any of the above once we check into the translation. Advisor, advocate, professional, or practitioner. Think any of
and
those.
I think we had variations on that on both of our surveys. So what you can hear in my voice is some concern that we're going to go back to square one, which I don't think is going to be productive, because we put out a lot of variations. We got back a lot of feedback that we then used to form a second survey. And then I will note 6 of our committee members did not respond to the second survey. And we are now bringing up some things that were brought up in the first round and rejected, and coming up with some new things. And I appreciate that why someone might not have thought of that before. We also have a problem that Leah needs to jump off in exactly 1 minute, and she's an integral part of this. So I'm going to try to take a couple of more comments, but I think that then we're going to have to wrap up the meeting, and Leah and I need to have a discussion about how to move this forward. Let me hear from Judge Yu. We haven't heard on from this, and Julia.
Thank you. I was just going to suggest that Justice Petru and Leah be in charge of choosing the name, and that, you know, there's too many cooks in the kitchen and too many words available to us. And I think we should just delegate this.
Well, I think part of what Leah and I need to discuss is whether it actually makes sense or not to do some kind of a public survey, whether that would be a fruitful part of the, you know, moving it forward. Julia?
So the one thing I would say is the reason I don't think we were expecting everybody just say, okay, the one that gets 6 votes, until the person on the call today said, think about it in another language, it had not occurred to me that we should not be using the word licensed, because it's absolutely confusable in Spanish. The second thing is, in addition to what Elizabeth found, there's another word in Spanish for advisor. So there's 2 different ways that could get translated. So I think the best thing would be to think about limited legal professional, because I don't know how practitioners gonna translate very well, but if you're gonna send out any more.
Then we have their acronym is, they're an LLP.
Yep, I like that.
And from prior conversations, I thought we did not like LLPs and LLCs. Are people fine with an LLP?
Again, for me, it's too confusing whether this person is an attorney.
Right.
Okay.
I'm sorry, Fariba, it's too confusing what?
It's not clear whether this person is an attorney, and self-represented litigants, again, aren't always, you know, educated in those things, and they're going to be confused.
Also, it might make it seem like it's a partnership.
Well, that's my concern. I mean, I hear LLP and I know what I think. Carolyn?
I'm tired.
Me too.
Maybe being creative is not the right, maybe Friday at 4 is not the right time to have the creative brains that we.
Well, I just am trying to gather some input, and we're going to call it quits. We're not making a decision right now. I do need to talk to Leah about how to move it forward. I think the big question on the table is going to include, you know, whether to try to really go way far beyond what any other state has done and include a public survey component. So let me just take a couple of last comments and then, you know, set everyone free for the weekend. Sharon and then Stephen.
I like the idea of doing a public survey component, and along those lines, it's not just Spanish, but maybe testing out the top 3 in the top 9 languages in California, because there may be some implications in Vietnamese, for example.
Yeah, I was thinking the same thing. Stephen?
I like limited legal advocate. I like the advocacy part because that's what we are authorizing them to do, advocate in court, and the limited legal for all the reasons Amos cited. So I would like it.
And am I wrong that someone raised the issue with the advocate not translating properly to, in a way that is okay to Spanish?
Yeah.
Yeah, I mean, it's a problem in Spanish. This is what I mean. There is very difficult. We are not going to come up. I mean, I want to come up with the best. Personally, I'd rather move forward 2 or 3 recommendations rather than 1. Because there is not going to be a term that someone doesn't find confusing in some way, that translates perfectly at all times, that takes into consideration all of the very valid issues that have been raised.
And I would refer to Julia on the confusion on defensora.
No, it was, if you use limited legal advocate, that's fine. It was advisor that has a couple different translations, but the advocate does not necessarily, but I will say defensora, I think that there may be another word in Spanish that could be used, and
Google
instead
showed
of,
me it's okay, but that was at least to take
Okay.
a review. Thank you.
All right, we're gonna have Judge Yu give us the last word here. But we want to be able to hear you, Judge Yu. You're muted.
I'm sorry, I think I forgot to lower my hand, but I also want to thank whoever made that public comments. Really, it was, the public comments are so helpful and that was really good.
All right. Well, then it is 4:04. We're 4 minutes past our time. We again have had a super informative and super productive day. Exactly. Give yourselves a round of applause. I really enjoyed the combination today of being able both to vote. Well, I don't get to vote, but getting to vote on substantive matters and also having good chunks of time to just discuss issues and get up to speed as a full group. So thank you to everyone. And I hope everyone has a good weekend.
And thank you, Justice
Thank
Petru,
you.
Bye.
for your
Bye.
chair. You got so
Have a
much
great
done
weekend,
today, Justice Petru. Thank you so much.
Talk to y'all soon.
Yeah, thank you.
Bye.
Thank you.